And so we've got a couple of our daughters that are in a courtship, and actually one is engaged now. Say there's quite a bit of difference between marrying off one of your sons and marrying off your daughters. Because I think with your son, it's kind of like you're bringing in a daughter-in-law into your family, but when you're actually allowing a guy to possibly marry one of your daughters, your protective mode is kicked in, and you're really evaluating, I think you evaluate actually a son-in-law a lot more than you do maybe even daughter-in-laws.
Joseph Duggar's legal team filed a motion on Friday that is raising serious questions about their strategy and their competence. And I want to walk you through exactly what they filed and what it means, because there is a lot happening in this case right now that deserves a careful and detailed breakdown. And before we get into the specifics of this new motion, let me give you the full context of where things stand legally, because understanding the sequence of events is essential to understanding why this new filing is so significant and so revealing about how the Duggar family approaches legal accountability. Joseph Duggar entered a not guilty plea, and on March 29th, he filed a standard motion for discovery and Brady evidence, which is the normal process in any criminal case where a defendant formally requests that the prosecution hand over all evidence that is favorable to the defense and all evidence the prosecution intends to use at trial. And that standard discovery motion covered everything from the names and statements of witnesses to police and investigative reports to any tangible objects obtained from the accused, to expert reports and scientific test results, to any evidence that might impeach prosecution witnesses or suggest bias or prior inconsistent statements. And the prosecution responded to that discovery request by providing evidence on April 8th and again on April 17th, all of which was designated confidential within the court, meaning the prosecution complied with the standard discovery process and handed over what they were required to hand over. Now here is where things get interesting and revealing. Rather than working with the evidence they received and building a defense based on what the prosecution actually has, Joseph's attorneys went back to the court and filed an additional motion, specifically seeking to compel disclosure of information that goes above and beyond what was provided in the standard discovery process. And specifically, they are targeting the records and testimony of DCFS investigators and child protection workers who were involved in the investigation of the victim in this case. And they are not just asking for Florida records, but for out-of-state records from Arkansas as well, meaning they want everything from every agency in every state that was involved in any aspect of this investigation. And the motion frames this sweeping request as a Sixth Amendment right to fair determination of guilt or innocence without providing any specific explanation of what the defense expects to find, why those records are material to the defense, or how the information would actually help Joseph at trial. The motion itself is raising eyebrows for reasons that go beyond just the aggressive scope of what is being requested. Because a motion to compel sensitive, protected information of this kind, information that is protected by specific Florida confidentiality statutes, would typically be a lengthy, detailed document that includes specific legal arguments, laying out the constitutional basis for the request. Case law citations supporting the argument that this type of protected information can be compelled in circumstances like these, specific identification of what the defense expects to find and why it is material to the defense theory, and a narrow, tailored request that demonstrates the defense has thought carefully about what they actually need, rather than just asking for everything in existence. But what Joseph's attorneys filed is essentially a barebones document that amounts to give us everything because we say we are entitled to it, with no explanation of what they expect to find. No argument about why specific records are material to the defense, no case law supporting the request, no effort to narrow the scope to what is actually relevant, and a citation to the wrong confidentiality statute. Because the attorneys cited Section 415.107 of Florida law as the confidentiality provision they were seeking to overcome, but Section 415 is the statute that covers vulnerable adults, not children. And the actual statute governing confidentiality of child protection records in child abuse cases in Florida is Section 39.02. And citing the wrong statute in a motion seeking to compel the disclosure of the very records protected by that statute is a basic error that reflects poorly on the preparation and expertise of the legal team handling Joseph's defense. Now, in Florida courts, and particularly in child sexual abuse cases, the legal environment for motions like this One is extremely challenging for defendants because Florida enacted significant new protective laws in 2025, specifically strengthening confidentiality protections for child victims in sexual abuse cases, including strong protections prohibiting depositions of children under 16 and victims who were under 12 at the time of the alleged offense, and providing robust statutory protections for the confidentiality of victim files and records. And Joseph's victim was 9 years old when the alleged abuse occurred, meaning she falls squarely within the most protected category under Florida law, and Florida courts are going to be extraordinarily reluctant to grant broad sweeping discovery into her. Confidential records based on a thin, barebones motion that does not even cite the correct confidentiality statute. And the standard judicial response to a motion like this in a case like this would be either to deny it outright or to conduct what is called an in-camera review, where the judge personally examines the protected files and determines what, if anything, is actually discoverable and relevant to the defense without exposing the full file to defense counsel. And the fact that Joseph's attorneys did not even request an in-camera review as an alternative, did not say to the judge, if you will not compel full disclosure, please at least review the files yourself and tell us what is there, suggests either that they did not think the motion through carefully, or that they filed it as a placeholder to get something on the docket before the arraignment, rather than as a seriously crafted legal argument they expected to succeed. The irony of this motion is something that deserves to be stated directly and without apology. The same Duggar family that spent years and significant legal resources fighting to keep Josh Duggar's juvenile records sealed. That sued the city of Springdale and Washington County and multiple public officials over the release of records related to Josh's crimes against his sisters. That specifically went to court to argue that juvenile records and DHS records were confidential and protected, and should not be released in response to Freedom of Information requests, is now filing motions asking a Florida court to compel the disclosure of confidential child protection records related to a 9-year-old victim. And the principle that protected those sisters' records is the same principle that protects this victim's records. And the Duggar family's position in practice appears to be that confidentiality of records matters deeply and deserves vigorous legal protection when it is their daughters being protected, and does not matter at all when the victim is someone else's child. And that is a morally indefensible position, no matter how many constitutional arguments are wrapped around it. Now I want to walk through the broader pattern of how this family has handled every legal challenge they have faced, because understanding that pattern is essential to understanding what is happening in Joseph's case right now. Because this is not the first time the Duggar legal strategy has involved attacking investigators, attacking public officials, attacking the credibility of the people doing their jobs, and seeking records and information designed to discredit rather than to genuinely investigate the truth. When Josh Duggar's juvenile police records were released in 2015, the family's response was not to acknowledge what those records contained and what had happened to the girls, but to attack the chief of police, Kathy Kelly, personally and professionally. And in one of the most disgraceful moves in this family's entire legal history, they argued that the reason Kathy Kelly released those records was because she was a lesbian who had a personal vendetta against the Duggar family, weaponizing her sexual orientation as a smear tactic in a transparent attempt to shift the conversation from what Josh had done to his sisters to the personal characteristics of the police officer who followed the law in responding to a public records request. And that argument failed, as it deserved to, but it established the template for every legal confrontation this family has had since. Find a person involved in the process, attack their character, claim their motives are impure, and use that attack to redirect attention away from the actual conduct at issue. When Josh was federally indicted, the family and Josh himself pivoted to claiming the entire prosecution was a politically motivated conspiracy orchestrated by the Biden administration, that Josh was being targeted because of the Duggar family's conservative Christian political ties and their public support for Donald Trump, that government officials opposed to conservative Christians were deliberately weaponizing the federal justice system against an innocent man. And Josh explicitly referenced his work in government lobbying and his connections to conservative political figures as the reason he was being persecuted. And this conspiracy theory has a problem so fundamental that it should have collapsed under its own weight from the moment it was articulated. The investigation into Josh began under the Trump administration, not the Biden administration, And Trump is the president of the United States right now. And yet the conspiracy narrative persists because it does not need to be factually coherent to serve its purpose. It just needs to give the community of Duggar supporters a story that allows them to maintain their loyalty to the family without having to reckon with what Josh actually did. The accusations of perjury against James Fottrell, the highly experienced Homeland Security Investigations forensic specialist, whose testimony about the forensic examination of Josh's computer was central to the prosecution's case, were made without credible evidence and went nowhere because the forensic evidence against Josh was overwhelming and specific, and tied to him through data timestamps and photographic evidence that could not be explained away by conspiracy theories about investigator bias. And yet the same family is now apparently preparing to pursue a similar strategy in Joseph's case, by seeking broad access to confidential files in hopes of finding something that can be characterized as investigator bias or investigative misconduct, or ulterior motives on the part of the victim's family. And the pattern is so consistent across so many years and so many legal proceedings that it is impossible to characterize it as anything other than a deliberate and calculated legal strategy, rather than a genuine good faith attempt to ensure a fair trial. The confession sits at the absolute center of this case, and it is worth being very specific about what the confession involves and why it makes certain defense strategies so difficult to execute convincingly. Joseph Duggar confessed to the victim's father, and that confession was recorded, and Joseph subsequently confessed again to law enforcement. And a recorded confession followed by a second confession to law enforcement is one of the most powerful evidentiary combinations a prosecutor can present to a jury in any criminal case. And Joseph's defense team is almost certainly going to argue that the first confession was made to a figure of pastoral or parental authority in a religious context, and was coerced or not fully voluntary, and that the second confession was made without proper advisement of rights or under conditions that render it inadmissible. And while these are arguments that defense attorneys are professionally obligated to advance, they are arguments that are very difficult to make credibly when two separate confessions exist and when the defendant's own family has publicly stated that. Joseph has taken accountability and apologized because you cannot simultaneously claim your client confessed under coercion and present him to the public as someone who has taken genuine accountability. The contrast between how Joseph's case is being defended and how Josh's case was defended is worth examining carefully, because it reveals something about the resources and attention being devoted to each brother's defense. Josh's attorneys filed extensive detailed motions with lengthy legal arguments, specific case law citations, carefully developed constitutional frameworks, and evidence of serious preparation and expertise, even if the ultimate outcome was predetermined by the overwhelming evidence against him. While the filings in Joseph's case so far feel generic and underprepared, like documents that were assembled quickly, without the kind of careful tailoring to the specific facts and legal landscape of this case that a life felony charge requires, and whether that reflects a difference in available resources, a difference in the attorneys involved, or a deliberate decision to run a minimal defense while pursuing parallel strategies through media and public relations, is something that will become clearer as the case develops. The question of what Joseph actually needs from those confidential DCFS files, what specific information his attorneys believe they will find there that would be material to his defense, is one that the motion does not answer and that the court is almost certainly going to ask. Because broad sweeping requests for highly protected information require specific justification in Florida courts, and judges are not going to open up confidential child protection files on the basis of a general assertion that the defendant is entitled to fair discovery. And if the defense theory is that the investigators were biased, or that the victim's family had ulterior motives, or that there is something in the forensic interview process that can be challenged, all of those theories need to be articulated specifically and supported by something more than a bare claim of Sixth Amendment entitlement, and the current motion does none of that. The victim in this case deserves to be centered in this conversation because she is the person whose life has been most significantly affected by everything that is happening in this legal proceeding. She was 9 years old when she was allegedly abused. She is now 14. She may eventually be required to testify in open court if this case goes to trial, because Joseph has demanded a jury trial rather than entering a guilty plea. And every aggressive discovery motion seeking access to her confidential records is a legal step that has the potential to expose her to further trauma and harm, regardless of whether any of those records are ultimately produced. And the Florida legislature enacted those 2025 victim protection laws specifically because cases like this one demonstrate how the legal process can become an instrument of re-victimization when defense strategies are built around attacking and discrediting the people who came forward, rather than around genuinely contesting the evidence of what happened. The bottom line of everything happening in Joseph Duggar's case right now is that his legal team is pursuing a strategy that mirrors the same failed playbook the Duggar family has used in every previous legal confrontation. Attack the investigators claim, persecution seek records that might discredit the victim and delay the process as long as possible. And they are doing it with motions that are too thin to succeed on their own terms. Cite the wrong statutes and will almost certainly be denied or so heavily narrowed by the court as to be functionally useless. And all of this is happening while the family publicly claims Joseph is taking accountability and has apologized. And those two stories cannot both be true at the same time. And the Florida courts and eventually a Florida jury are going to have to reckon with that contradiction. And based on everything we know about how these cases go, when a defendant has confessed twice and the forensic and testimonial evidence is substantial, the outcome of that reckoning is not difficult to predict.